Chief Justice Stephen Gonzalez of the Washington State Supreme Court. Hey, thank you so much for taking the time to join us. We appreciate it.
Glad to be here.
So, there was a crosscut poll that came out not too long ago, and the headline from that poll, among several items that they looked at, was how people viewed the U.S. Supreme Court today. And the feeling out of that polling was that people are not feeling like they can trust the court as they once did. How do you view it?
Well, there's been a lot of bad press for the Supreme Court. Some of it deserved, and some of it maybe more than it should be. But they've had a lot of bad press, and unfortunately, that discussion about the decline in trust and confidence in the U.S. Supreme Court goes hand in hand with the latest testing of eighth graders' knowledge of civics and history, which is in a steep decline. And it got bad during the pandemic, but it had started way back, I think, in 2014, if not before. And our democracy only works if we have an educated populace. That's the function of it. And unfortunately, we don't. And so when the U.S. Supreme Court is getting hit by bad press and people don't understand the difference between a federal court and a state court, we get smeared with that same bad press. And so it detracts from our ability to gain that trust and confidence in the public. So I'm very concerned about it. I think the U.S. Supreme Court should adopt a code of ethics. I don't know why they insist on not doing that. The final answer in what federal law is should not be above the law. So they need to adopt that.
Are they overly politicized now?
Well, the whole nation is overly politicized. The court's overly politicized, but the real question is, are they overly political? Is the work that they're doing political? And the problem is the coverage of some high-profile cases in which they seem to have let go of precedent, despite having said and promised that they would cleave to it during their appointment hearings. And there does seem to be a tension between what they said they would do and what some of them actually did. When you couple that together with coverage of the shadow docket, coverage of contributions made to them, activities of spouses, real estate transactions, leaks of opinions that should never be leaked before they officially come out. It's a whole series of things together. So if they're a little more political than they were before, it's been amplified. So they're fitting right into this national narrative of a divide, that you're on one side or the other, when the truth has to be, if we're going to survive this, somewhere in between, where we understand each other, we compromise with each other, and we respect each other. And I see that missing. And when I talk about respect, I don't mean etiquette or politeness or even necessarily following the rules all the time. It means actually listening to each other, the substance and the heart of what they're saying, even when it's sometimes wrapped in emotion. If that emotion is sincere, you make room for it and you try to get past it and really delve into what the substance of the complaint, the concern, or the need is. And I fear we're not doing that enough.
Yeah. So to me, the big public opinion turning point was Roe v. Wade. I grew up with it being law, and all of a sudden it gets overturned. And clearly that's not where the public was. Did that really diminish the credibility of the Supreme Court, that one ruling?
You ask an interesting question, which presumes maybe something that I'm not quite so sanguine about.
Mm-hmm.
And that is that popular opinion should matter to what the court does. I don't think it should. And that's because the court's job is to protect the rights sometimes of the minority against the majority. So that shouldn't be the test. And so I'm not so concerned when the court...
That's a really good point.
Yeah. So I'm not so concerned when the court decides something that isn't necessarily popular. But I am concerned when it switches from what is longstanding precedent without a convincing analysis supporting why we should do so. You know, we're in an interesting time where up until recently, you had the conservatives arguing about states' rights and the liberals talking about federalism. Now, all of a sudden, that's been flipped, in part because of the change in the makeup of the Supreme Court, where it's states' rights to protect us and forget about those feds. The truth again is somewhere in between, because the relationship between states and the federal government is complicated. There's some things we get to do. The 14th Amendment helped us clarify a bit of that relationship, but there's some things that are federal and there's some things that are the state. And there's a real difference between state law analysis and federal law analysis. The federal government is a government of limited power. And unless they have been authorized to do something in the Constitution, they don't get to do it. So the question is, what gives you the right to do that, federal government? But the question we ask in the state is very different. We get to do anything unless we're prohibited from doing it, either in the federal Constitution or in our state Constitution. So the question is not the same at all. It's, well, why can't we do it? As opposed to what lets you do that. That is lost. If you ask that of most college graduates, even if they're history or political science majors, they can't tell you that difference. Many law graduates can't tell you that difference. I'm worried about the nature of the level of civics and history education. And I'm worried about some of the movements that take books away from kids or tell teachers what they can and can't teach. I think we better have enough confidence in our kids to discern what's good and what's bad, or what they think should be done or shouldn't be done. And if we're not trusting them to do that, how are they going to step up and be the leaders that we need in the future?
Two justices said during their hearings on the whole issue of abortion, they basically backed the idea that it had already been in place and that it would not be something that they looked to change. And then it was. Who's to blame? Or did John Roberts lose control as Chief Justice of the Supreme Court?
Is it his to control? I'm going to the premise of your question. Did he lose control? One, did he ever have it? And two, is it his to control? The leader, like I'm the chief of this court in the state of Washington, I shouldn't be controlling where we go. I should be listening to the opinions of my colleagues, helping us form a cohesive majority of a direction to go, and then helping to implement that. Because the court has two roles, at least. One is to hear the cases, and the other is to administer the judicial branch. And it's important to be collaborative and inclusive when doing that.
Yeah.
But back to the heart of your question, the court needs to regain the legitimacy that it has lost. It needs to take responsibility for helping the public trust them more again, which is why I started off by saying they need to adopt a code of conduct. They need canons or judicial conduct or whatever it is, and then someone who can actually keep them in compliance with it. That sort of oversight is needed, in the same way that law enforcement will be better off if there is some oversight of their own use of force and discipline provisions. I remember years ago when I used to be a federal prosecutor, the FBI was very resistant to recording interviews with suspects. They thought our credibility should be enough. We should write the report afterwards, and everybody should trust us when we say what happened. Once they actually adopted it, though, that resistance fell away, because all of a sudden, their credibility wasn't being attacked. They could just say, here's the video of what happened. If you don't believe me, here it is. And you could get past all of that casting of aspersions on character and just talk about the content of it instead.
Yeah.
And I think the same thing will be true of the United States Supreme Court. They should let cameras in. They should be live streamed, every oral argument, so we can watch them, hear the questions that are put to counsel and the answers that counsel give, and understand better what they do. I don't understand that resistance to openness.
Well, what has transpired and come about Clarence Thomas and accepting these trips, do you think he should resign?
I'm going to refrain from answering that question. I have opinions about it. I think there's a real problem with his credibility right now. I don't know how he's going to address that. He has been pretty taciturn in the past. I don't expect that all of a sudden he's going to change and start explaining himself more. So I'm concerned. I think he's part of the problem. I think he could fix it. Maybe that is where the chief's leadership should come in, to find a way to to convince the public that he's going to be more transparent and we can have more trust in his approach to the law. But that really is for them to work out.
What do you guys, as Washington State Supreme Court justices, need to abide by when it comes to ethics and making sure you're not making those kinds of mistakes or coming out with items or information that is not good for the court?
Yeah. Well, there's a code for judicial conduct that we all must adhere to. So that code itself tells us what we should or shouldn't do. And we don't just interpret it ourselves. There's a Judicial Conduct Commission, which is a separate entity that was set up to review complaints about judges and their compliance with the code for judicial conduct. So we have a robust system. And in addition to that system of evaluating judges, and some judges have been taken to task and even removed when they violated those rules. But in addition to that, we have a fairly robust Public Disclosure Commission, which applies to us because judges in this state are elected officials. So we have to disclose our campaign contributions and expenditures. And we also have to submit our F1 records every year, where we say if we ever accepted a free dinner or a free lunch, let alone a trip on a yacht or a jet trip. Everything that we're doing financially is in those disclosures. And we're much more accountable and transparent that way. Sometimes I wish my life wasn't quite such an open book, but it's the job that I step forward to fill.
So why isn't that happening at the Supreme Court, in the U.S. Supreme Court?
Well, we have this issue of separation of powers. And so the legislative branch and the executive branch's authority to make them do it is in question. If they tried it, well, maybe the Supreme Court could just ignore it or issue an order saying it doesn't apply to them. It really, in my view, is good government. And it is what the Supreme Court should itself adopt and agree to adhere to. The Code of Judicial Conduct is something we have a say about, but we've adopted it and we've said it applies even to us, not just to the judges below us, but to us. And I'm hoping that the public pressure on the Supreme Court will lead them to do the same thing. The American Bar Association was urged by delegates from our state to support the Supreme Court adopting and to pressure them to adopt such a code of conduct. I hope they'll listen to those cries. They'll understand the poll results showing the decline in the public trust and confidence in them and take steps to fix it. I really hope they will.
Well, how many other states have appointed Supreme Court justices for life? Or is it just the federal Supreme Court?
That's the federal Supreme Court system. There are some appointments which are for longer duration. Some have term limits. Some you get one 12-year term and you're done. Others have retention elections. Some have elections that are nonpartisan, like we do in Washington State. And a handful of states have partisan elections where you run for judge on a partisan ticket, which to me seems antithetical with the whole idea of being neutral. But each state gets to choose the way it selects its judges and justices. But it's only the federal system that is for life.
Yeah. So federal judges it's lifetime appointments, right?
That's right. And the theory behind that is that you don't want them to be worried about politics. You want them to be free of that influence. And there have been some justices who were appointed, and the worry was that they were going to be beholden to the party that represented the president who chose them, but went their own way and demonstrated that independence. I'm not sure it's going to work in all cases, and there are certainly some problems with it. The problem with, of course, electing judges is that they're going to be afraid of what the popular opinion is and do what they think is popular, even if that means sacrificing the rights of the minority. Well, there are problems either way. You don't want judges worrying about the next election when they're deciding what the appropriate sentence is in a high-profile criminal case, for example. But some studies have shown that there is an influence. In fact, in our own state, the studies show that judges are harsher in their sentencing in the year before they're up for election than they are in the other years that they're on the bench.
Yeah.
It's closer to home. The legislature just reconvened a special session to adopt the criminalization of drugs, and that stems from a ruling the Washington State Supreme Court made about the unfairness of the existing law. Did you expect it to play out like it did in the current session? I mean, they finally got it addressed, but what were what was the court thinking when they did that?
Sure, and I can only answer for myself. I didn't know what the legislative response to the court's decision would be. You're referring to the Blake decision,
Yes.
which we said that the statute, which made possession of a controlled substance a felony without the state having to prove mental state, that is, that the person even knew they had the drugs, was problematic, in fact, unconstitutional. But the next step, what should the law be instead, or should there be a law instead, is a policy question that we shouldn't be answering, the legislative branch should be answering, and the executive branch should be enforcing based on what the legislative branch decides. So they had a choice. They could, as some argued for, simply have added a mental state element to the previous law. Because before it was strict liability. So if I handed you a bag and said, can you put this in your trunk while we go shopping? If it had drugs in it and you had it and put it in your trunk, you were strictly liable. You could be found guilty for possession of the controlled substance, even though you had no idea what was in my bag. Well, they could have just said, you only get convicted if you knew or should have known what was in that bag. Maybe it smelled really strong of what was in there, and you could tell, you knew better, but you put it in your car anyway. So they could have just added that mental state element. Or they could have made it into a felony with other conditions. They could have made the penalties harsher. They could have made it a gross misdemeanor or a simple misdemeanor. And a gross misdemeanor is punishable usually by up to 364 days in custody. Or they could have made it a simple misdemeanor, which is usually punishable by up to 90 or 180 days. They could also precondition charges on treatment being offered first. But that means that there actually has to be treatment available, which isn't true everywhere in the state of Washington or in sufficient numbers anywhere in the state of Washington. Those are all choices for the other branch of government, not for us.
So the role that the court played was they saw a law that was unjust and corrected it. And to re-implement the policy is up to the legislature.
And again, I'm sorry to keep disagreeing with the way you posed the question.
Okay, no, that's fine.
We didn't correct it. All we are a very blunt tool in many ways. We can't say what you should do instead is this. What we say is the way you've written it is unconstitutional. Try again.
Okay.
It's their job to correct it. And what is correct? Well, for us, the only thing that was incorrect is that they were able to convict people without proving that they had intent to do a bad thing. So to that extent, you're right. We corrected that deficit in the law. But reenacting a law that doesn't have that defect is their job.
So do you think they fixed it?
Well, they had an interim law in place that criminalized possession. They now have a new law in place that doesn't have the same 2-year sunset provision that criminalizes it. We'll see whether that corrects the problem, whatever the problem is, because the problems are myriad. The problems are that there are many people addicted to controlled substances, and that when they're so addicted, they often act out in ways that affect not just themselves and their families, but the community writ large, because they're involved in other criminal activity, self-harm, or harm of others. So that's a problem. There's the problem of the cost of doing it. There's the problem of the disproportional effect of the way that the laws were enforced before on low income and communities of color. So there are all kinds of problems, and the correction is going to be aimed at correcting all of them. And I think that's a very difficult problem. So we as a society need to decide how we're going to deal with people who are mentally ill and people who are addicted to controlled substances in a humane way. And judges are not always the answer.
Yeah. Do you expect this to come back to the court at some point?
Probably. There may well be legal challenges to the new law. I don't know what those will be or how they'll work their way up here. I can imagine someone will say, I was charged. I wanted to do treatment. There was no treatment available in my community. Therefore, they shouldn't have been able to charge me, but they did anyway. We'll have to decide whether the executive branch had the authority under the statute to charge a given individual, given the treatment requirements that are set up. There's also the question of, well, who pays for that treatment? Should the court be going out and buying halfway houses to put people in before we put them in jail? Does the executive branch do it? When I say executive branch, is it the county? Is it the state? Is it the city in which the person is charged? These are very complicated questions, and we're going to have to spend some time with the statute, and then cases may or may not be filed.
We'll see. I want to go back to 2020 and after the murder of George Floyd and how the court sent out a letter. I want to read a little bit about what was in that letter. As judges, we must recognize the role we've played in devaluing Black lives, and it is only by carefully reflecting on our actions, taking individual responsibility for them, and constantly striving for better that we can address the shameful legacy that we inherit. Pretty remarkable statement for, a court to come out with.
Events after George Floyd was killed had a profound effect nationwide. And I think they also had an effect on the trust and confidence in the judicial branch. Often we are passive in our role, and that's appropriate for cases. We hear the cases that come to us. We don't reach out and decide what it is we think we should tackle next. That's not the nature of our work. On the other hand, we administer the entire judicial branch by setting up the rules, by convening discussions about trends and upcoming problems. For example, we have our Board of Judicial Administration meeting coming up, where we're going to talk about the severe lack of public defenders available, especially in some rural parts of the state, to try to get some traction and some progress made in improving that. So in this instance, we were recognizing the problem of the use of force against people of color. And those cases, many of them, come to us. They're either prosecuted by prosecutors, defended by defense lawyers, heard by judges, or they're in civil cases where someone is suing for and asserting liability against someone for what's happened. We wanted to recognize that we've had some role in getting us to the place where we are right now, that some of the opinions we've issued in the past have language that is unfortunate, inappropriate, and creates harm. And acknowledge that we have some responsibility as at least one independent branch in this government, in this state government, of admitting that we've made mistakes in the past and that we have work to do. That it's not just those actors that bring cases to us, but it's we ourselves who set the rules for how we adjudicate those cases and how we interpret the decisions we've made before, and how we reform our systems and our rules to make sure that they're as equitable, fair, and open as possible.
There was a recent case in which you actually are giving a new trial to an African-American man who, in his trial, there were, I guess, two Black prospective jurors, and both of them were excluded from the jury in his case. Does that reflect what the intent of that letter was all about?
You're referring to the Roan case, as RHONE. I guess it's part of that. It's part of looking back at court decisions we've made and rules we've had in place and re-examining them. I'd say a bigger step in that regard is our adoption of General Rule 37, which changes the whole way juries are now selected. There's a federal case, Batson versus Kentucky, that was supposed to eliminate or reduce bias in jury deselection, that is, those who are removed from the jury. But it's widely understood to be a complete failure in doing so, because in order for a judge to say that a juror shouldn't be removed, they have to find that one of the lawyers was intentionally being racist. And that's unlikely to happen, and it's hard to know. But we changed the rule now to be that of an objective observer, so that if an objective observer, defined as somebody who's aware of the history of bias in the system, could conclude that race was a factor, you can't remove that juror unless there's a cause that you can show why that juror can't be fair and impartial. It is resulting so far as we can tell now, in more diverse juries, more close attention being paid in training sessions about implicit bias and race for lawyers and for judges. And I think better outcomes, because all the studies show that diverse juries are better than homogeneous juries. They spend more time talking to each other. They actually read and follow the directions from the court more closely, and they take more time examining the exhibits that have been admitted in evidence. So on all the objective measures, they're better, except they might take a little more time, which is just fine. I'll accept a little more time if they're doing those other things better than the other juries are.
Yeah. When this letter came out, or in the whole process of writing that letter, coming to that agreement among the justices to do so, were you concerned about all of that?
Well, I was. First, when this letter came out, I wasn't the chief yet. Justice Stevens was. It was her idea to issue a letter, and my initial response was, well, I'm not sure we should do that. I haven't seen a draft yet. I don't know what we would say, and I'm not confident that we'd be able to live up to it. And I don't want to put out a promise if we're not actually going to do it. And it was Justice Yu who drafted the initial letter.
Mary Yu, yeah, Justice Mary Yu, yeah.
Justice Mary Yu, who said, well, let's see what we can do. Let's make a promise and then live up to it. And so I was the jaded one at the time. She was the one who said, well, come on, let's give it a try. And all 9 of us, after some hard work, because we didn't immediately all say, yeah, let's do this, me included. But once we saw the product and we're all able to sign it, I think it's been of great help. And I've heard from trial judges who said, well, thank you for saying that and giving us at least an avenue to open these discussions and to do this hard work and to give us some cover to do what some would criticize is itself a political step. I think it isn't. I think our responsibility is to administer the judicial branch of government, and that takes leadership sometimes.
Yeah.
So getting back to the Supreme Court of the United States, what if they don't do anything? What if it just keeps going on? Does that put the system of checks and balances in jeopardy?
Yes. You're probably hoping for a longer answer.
Well, we know you're a justice, so we know you're going to really think about it.
But I just worry about, where we are as a country. I mean, it seems like there's always a hope that the Supreme Court would be sort of a voice of reason. And I don't really know if they are or not, because the way news presents the stories, it's hard to tell what is real, what isn't. And so I'm just concerned because any hint of delegitimacy of the court really unbalances the system more so than anything else.
I don't want to pile on. They are issuing opinions every year. Many of them are just fine, well-reasoned, and not politicized. So I haven't lost my faith in the 3 branches of government and the way it works. I haven't lost my faith in the importance of state constitutions and the state judiciary. I've always believed that we need to be developing our own jurisprudence because we are different. Each state has the right to interpret its own constitution. Our Constitution provides more protection, for example, than the Fourth Amendment of the U.S. Constitution does. Our Article 1, Section 7 says that the government may not interfere with your private affairs without authority of law. It explicitly gives each of us a right to privacy. That is not explicit anywhere, and whether it's implicitly a right or not under the federal Constitution is now in question. But here in Washington, you have a right to privacy.
Mm-hmm. So another contentious thing is the legislature just passed an assault weapons ban. Do you fully expect that to appear in front of your court?
It might or it might not. There have been cases filed, but I think they've been filed mostly in federal court. Mm-hmm. So it may be that we'll never hear a challenge. There will be challenges to it. Some of them may come here, but they may also be in federal court.
So how does that work, that they can bypass state courts and go directly to the federal court?
Well, I don't know if it's bypassing. There is shared jurisdiction over the U.S. Constitution. So if there's a question of state law, that is the state constitution, they can't go to the federal court to try to get that answer. We're the ones who say what state law is, but we can't provide less protection than the federal Constitution does. If there's a question of what the federal Constitution means, they can come to state court or federal court. We also get to interpret the US Constitution. Now, if our answer is that a new law, whatever it might be, violates the Washington Constitution, that's the end of it. There is no one else who gets to say what the Washington Constitution means. If we say that a law violates the US Constitution, then the US Supreme Court could review our work there. Sometimes there are cases that go to federal court because there are controversies between people from two different states. And so they end up in federal court rather than state court. But there's a state court question. In that instance, the federal court usually certifies a question to us and says, tell us what Washington law says about A, B, and C. And we answer them so that they can proceed with the federal court because of diversity jurisdiction, but with an answer about Washington law from the Washington Supreme Court. Yeah. There are other instances where things can be in either state or federal court, or where they can only be in federal court. So certain crimes that happen, for example, on federal property, they're going to be in federal court. But a crime like bank robbery, which is criminalized both under state law and federal law, could go either place. So you're going to see a challenge like one under the Second Amendment that might go to a challenge in federal court. They might say, this affects the right of interstate commerce. We're buying automatic weapons from another state and we want to sell them here. So it's a diversity jurisdiction, interstate commerce question. It should be in federal court. It's a national company that is bringing it. So there are different reasons why it might be in federal or state court, but the two systems work together.
You bemoan the fact that we don't really pay attention or teach civics in our schools these days. So what is our state Supreme Court doing to try to rectify that, if anything?
Great question. So we just got back from our traveling court program, which we do 3 times a year. This time we were invited to Whidbey Island, and we traveled to 3 different school districts there and spoke to high school students about what we do, which is civics education itself. We also make judges and justices available. You can find them through the administrative office of the court to go speak to schools throughout the state, to history classes, to general assemblies. And we do that when invited. I frequently go and speak at schools, and I've gone as young as preschool and kindergarten, as well as elementary, middle, high school, college, and law schools.
Do you wear your robe when you do that so they could see what? I mean, for little kids, they'd like that.
I did when I went to the preschool. In fact, when I told the teachers I was coming with a PowerPoint, they said, "You do know that these are preschool students." I did know that. I brought pictures of our kids and talked about the mock trials that they used to conduct in the bathtub every evening. And so they were quite engaged and enthralled with it. And we talked about what the job of a judge is. And in some ways, those preschool kids got a pretty good idea of what we do.
Yeah. So why are we so behind on this stuff? I mean, why aren't we teaching civics in schools anymore? And it just seems like we need that more than ever now.
These conversations are hard, I think. And in some ways, we avoid things that are hard. There's also been a real emphasis on STEM education, which is great,
right,
but not when we exclude those other things. I think that we develop best when we understand other people. And one way to do that is speaking more than one language, for example. And when I talk about more than one language, math is a language, art is a language, music is a language, but all of our students need to speak at least one other language aside just from English in our schools. We also need to understand civics because, as has often been said, that's how democracy works. A well-educated populace is what makes it function. Because you can't rely on people to elect leaders if they don't understand what those leaders are going to do, what their responsibilities will be.
Yeah. How many languages do you speak now?
Still working on my English. I speak
me too.
Japanese, Spanish, and Mandarin Chinese.
Wow.
Wow.
Well, you beat
impressive.
Come on, Matt. Where are you on all this?
I don't mean to
I know
say,
many languages.
Yeah. Well, yeah, I don't know about that. I want to talk about something else that you and I lost a friend recently.
we did.
Artist name Alfredo Arreguin. And as we record this, we're also doing it for our YouTube broadcast. There's a beautiful painting behind you that Alfredo did, and I have one over my shoulder, a serigraph that Alfredo was a wonderful friend of mine, and I think I might have done the first piece about him back in the '80s. Oh yes, and you brought something to the court that Alfredo contributed. Can talk about that?
Thank you for that question. What a great person Alfredo was, and our respect to his wife, Suzanne Lytle. When I first came to the court, when I was going to be appointed 11, 12 years ago now, our kids who were 7 and 8 years old at the time came with us, and we walked through the halls of the Temple of Justice, which is the name of the Supreme Court building. And our younger son, who was 7, said, "Dad, how come none of them look like us?" And to me, that points out exactly the problem with the lack of diversity. We need to encourage people to imagine themselves in those leadership roles. We need kids of color to dream big, and we need white kids to change their view of what a judge looks like. Because if they think a judge looks like an old white person, there's a problem there too. So I promised Isaac that we would change that. So I thought, well, now that I've made this promise, how am I going to do that? And so I reached out to Alfredo and I said, look, we've got these portraits that line the halls at the Temple of Justice, and they're all in a classical style with muted tones, and they're all men, and they're all white. Can you help us? Because one of my mentors was Justice Charles Z. Smith, who was the only other person of color ever to serve on the Supreme Court before I joined the court. And he'd retired 10 years before I joined the court. And there was no picture of him anywhere at the Supreme Court. And so I introduced the two of them, and then I worked hard to try to find a way to fund it. And the court said no to me when I proposed that we pay for a portrait of C.Z. Smith. The Historical Society said no. And I told Alfredo that I wasn't sure I could pay for it yet, and I certainly didn't have the funds yet. And he started painting anyway. And months later, when I checked in with him and I said, I'm making some progress, we've got some commitment to funding, but I still don't have enough to pay you. He said, look, if we wait for you to get this funded, I'm not sure that Justice Smith or I will still be around. So I'm going to give you the painting and let you figure out how to pay me for it later. We were able to pay him eventually, but he gave us the painting, I guess, on credit. And one of the concerns he expressed to me was, he said, well, all the paintings are in a classical style and mine is more like jazz. And I said, really, I'm not sure I agree. Yours is more like cumbia. You change things. And so this painting now exists, and there's a copy of it at the University of Washington, where he was an assistant dean for a time, an associate dean for a time. But we have this now at the court, and we were able to present it at a Minority and Justice Commission symposium with Justice Smith and his wife, Ellie, there for the presentation. And following that presentation, I then asked him to paint the first woman of color ever on the court, Justice Mary Yu. And again, I didn't have the funding right away, and he agreed to paint, and we were able finally to get that funded as well. And let me see if I can find that one for you, because in my view, it's stunningly beautiful. Right. It is a picture of Justice Mary Yu.
Wow. Yeah, it's gorgeous.
And then, of course, to teach me a lesson, Justice Yu then asked him to paint one of me, and Justice Arreguin did a painting of me as well. And I had told Alfredo that growing up in my family home, right there in front of the front door, so I saw it every time I would leave the house, were two portraits, one of Emiliano Zapata and the other of Pancho Villa. So he decided I needed Emiliano and Pancho over my shoulders to give stories. So he included them in the painting.
Right. Oh, they're just beautiful. They're just
Yeah.
beautiful, and they also, I think, give the court some spice, a bit of salsa, and with all of that. And that was the one thing about Alfredo. He was so generous that I did a story, and it was similar where he did a painting about Hazel Wolf, the environmentalist. And again, it was one of those things where Ken Jacobson, who had been a state legislator, had asked him to do this painting, and he says, "Well, let me think about it." And then next thing you know, he painted it, and because he was just so efficient and prolific in everything he did. So we're very fortunate that to have that, and God, his just work was just incredible. So he will be greatly missed. I have one other thing I want to ask you before we close. I don't know if Matt has anything else, but I did a documentary back in 2012, and you were a part of that, and we were talking about just the whole issue of justice and politics. And at the time when you ran the first time around, it might not have changed much then, but the issue of Gonzalez on the ballot, the name of Gonzalez was an issue, and it as far as winning votes or getting the votes that you needed to be elected to the state Supreme Court, is it still an issue? Because Gonzalez is an American name. You were born here.
It is. I'm born here, and my family on both sides have many generations here. One side through Ellis Island and the other from Mexico. Unfortunately, I think, especially in certain parts of this state, a last name with a Z in it is still an issue, and we'll see that play out. I think it's getting better every year. It's partly why I decided to go ahead and pursue a position here on the court. There had never been a man of color elected to the Supreme Court in a contested race, ever. And every time it happens, it gets easier for the next person. What, of course, we want is not someone chosen because of their background, but what we want is nobody excluded because of their demographics. And that's what we're shooting for it really to be a meritocracy, as we're hoping it should be, and that we evaluate judicial candidates on their merits, not on their name or their color or their gender. I do think we're making progress, as I said. I don't think we've completed that work or anywhere close to it yet.
Yeah. Well, thank you and your fellow justices for the role that you play in our state. We appreciate it.
As always, I'm so happy that I live in the state of Washington.
Yeah. I think, when we ask you questions about our concerns of the judicial system, and I'm sure that we could use a number of courses in civics, it's just that we worry about our democracy. And as aging TV guys, we worry about it more and more each day. So, but we really appreciate you taking the time, Chief Justice Gonzalez, to take the time to talk to us and talk about the court. And hope you'll come back and educate us some more.
Thank you both very much. There are 39 counties in the state of Washington. We elect our justices to 6-year terms. There are 9 of us. So the terms are staggered. Every 2 years, 3 of us are up for election. So please, if you're out there and you're a voter in Washington, educate yourself and participate in the selection of the members of our court.
Thank you for educating us just right now. All right. Thank you, Mr. Chief Justice.
You're welcome. Thank you.